Continue with our discussion of the principal-agency relationship and how it relates to legal liability and the like. We're going to start with implied authority. We discussed this previously in the context of what is necessary or what is apparent or what is ratified. If any of the agent's activities are ratified or if it is apparent, then the agent has the authority implied by whatever the action is or whatever the circumstances is to carry out the authority of the principal. Third parties are entitled to rely upon that implied authority. We've discussed apparent authority in the context of agency by estoppel, and generally this is the same thing that we're talking about here. If the principal causes a third party to reasonably believe that the agent has the authority to act for the principal, then in fact they do have that authority to act for the principal. That's known as agency by estoppel or apparent authority. Agency by operation of law occurs in a couple of instances. One, if the actions are for necessaries, and the other, if the actions are in an emergency situation. Generally speaking, the agent should be in a situation where they can protect the principal and they are not able, for whatever reason or reasons, to communicate with the principal. The example I gave in class at the end of class last time was if a principal was unconscious and needed emergency medical care, then the agent would have the right to act on behalf of the principal even without express authority. Ratification requires a couple of very specific type of events to occur. First and most important is that the action must be on behalf of the principal. So if an agent is acting for their own behalf, then that is not and cannot be an agency by ratification. The second, and this is one that is very often missed, good test question, is that the principal must affirm the entire deal. Let's assume that an agent had good intentions, went out and negotiated a deal for the principal to purchase 50 tons of gravel at $100 a ton. The agent comes back to the principal, advises what they have done, and the principal says, "Great, I need some gravel. $100 a ton is a wonderful price, but I don't need 50 tons. I only need 25. The principal cannot affirm half of the deal. They either have to affirm all of the deal or none of the deal. Third part is that they must affirm before the third party withdraws from the transaction. It could be that the agent is not even known to be acting in an agency capacity with the principal, for the principal, and the third party is unaware. Well, if the third party becomes aware and decides to withdraw from the contract, then they are entitled to do so up until the point where the principal has affirmed the deal. So the principal must act quickly, or at least more quickly than the third party can withdraw from the deal. Finally, the principal and the third party must have legal capacity to contract when the agent made the deal. If you notice, there's a very important item missing, and that is the agent does not have to have legal capacity to enter into a contract. They do not have to have contractual capacity as long as the principal and the third party have that capacity. Finally, the principal must know all of the material facts involved in the transaction. If there are material facts that are undisclosed, it is incapable of proper ratification. I'm going to skip slide 22 because there's not a lot of practical application regarding disclosed, partially disclosed, and undisclosed principles. And for the most part, common sense would prevail. Moving over to slide 25. If an action by the agent is not within the scope of their express authority, their implied authority, or their apparent authority, then they in fact have no authority to act on behalf of the principal. This does not mean that the third party is without a remedy, however. Instead, in that case, the agent himself or herself is personally liable, but the principal is not. A lot of times people are a little confused by the concept of companies being sued for the torts of their employees. We've already discussed and reached the conclusion that an employee can bind the employer, and the employer can be held liable for the actions of the employee under a principal-agency relationship in theory. Well, a lot of times the confusion arises from those that believe the employee is somehow getting off the hook. That's not exactly the case. Instead, the agent or the employee in an employer-employee relationship acting as the agent is also personally liable for their own tortious conduct. So you have that truck driver that falls asleep at the wheel, crosses the median, and is involved in an accident. Yes, the trucking company can be held liable for that tortious conduct, the negligence of the truck driver in falling asleep while driving on the road and crossing the median. But the truck driver also can be held personally liable, and in fact, the company is generally not liable unless the truck driver is liable. And that makes sense when you think about it. Why should the principal be liable unless the agent is also liable? Because the principal is liable for the tortious conduct of the agent. Now, the principal is not always liable for the agent's tortious conduct, but generally speaking, they are going to be liable in many different situations. If the principal themselves commits the tort, obviously the principal will be liable. If the principal authorized the tort, then they will be liable. And finally, if the agent was, even if the agent committed an unauthorized but fraudulent tort and engaged in fraudulent conduct, as long as it is within the scope of the agency, then the principal can still be held liable. You recall the case where we sued Fireman's Fund for the tortious, fraudulent conduct of the employee in selling life insurance policies by representing that they were retirement instruments instead. Well, in that case, the principal was held liable for two reasons. One is that the principal themselves authorized the tort. In fact, we proved in that case that they trained their employees how to sell and how to defraud the public in purchasing these products. In addition, even if we were not successful in proving that, as long as selling the product was within the scope of the employee's relationship there with the company, then even if that selling of the product as misrepresenting it as a retirement policy, even if that was not authorized by the company would still be liable because that is within the scope of the agency relationship. Slide number 27 basically is a review of what we've already discussed. As long as the agent had apparent actual authority made within the scope of their authority, then the principal can be liable for misrepresentation, as well as liable when third parties are given a mistaken impression that the agent had authority. Nothing horribly complicated here, and I won't get too complex or tricky on an exam. Definitionally speaking, the concept that under the law where the employer is held liable for the employee's action is known as the doctrine of respondeat superior. And the doctrine of respondeat superior says very clearly that the employer is vicariously liable for the negligent torts committed as long as it's within the course and scope of employment. Let's take a look at that for a minute. Was the employee's act authorized by the employer? If so, obviously, the employer is going to be liable, as that is clearly within the scope of the employment. The time and place and purpose of the act, basically you're looking at all the facts and circumstances here. And that may or may not point to the employer being liable as within the scope of the employment or not, depending upon all of those type of circumstances. Was the act commonly performed by employees? If so, typically the employer would be liable. Was the act for the benefit of the employer? Did it advance the employer's interest? If so, again, employer liable. Did the employer furnish the tools of the trade? This is sounding an awful lot like the difference between an employee and an independent contractor, isn't it? And the truth is that the factors should be similar because you're undergoing a similar analysis in determining scope of employment as you are control element for an employer-employee relationship in the first place. But yes, if the employer furnished the tools of the trade, the tools in which the employee used to commit the tortious act, typically the employer will be liable. Again, this is not an absolute. None of these are absolutes. Did the employer know or have reason to know the employee would commit the act? If so, yes, employer is liable. Did the act involve a serious crime? Here, the general rule is that the employer is not liable in a case where the act involved a serious crime. Obviously, if that serious crime is authorized by the employer, then it puts it into the top category, and the employer would be liable. If it advanced the employer's interest, it could potentially be, the employer potentially could be liable as well. If the employer had reason to know the employee would commit the act or commit the serious crime, then I believe that most courts would hold the employer liable in that case as well, too. I have discussed with you briefly, and we'll discuss more when we reach the employment law section of the course, a case involving an employee who was the victim of a potential attempted rape. And in that case, we sued the company for a variety of reasons that will be discussed more thoroughly when we get to the employment law portion of the course. But in that case, the company actually knew that the person had committed a similar crime in the past, and all they did was move the person to another store so they could do it again. We argued that they had reason to know that he would commit the crime, serious crime again, because he had a history of doing so. Couple of interesting exceptions, and you know the law is nothing if not filled with exceptions. Generally speaking, if an employee engages in something usually called a frolic and detour, or a detour or frolic, depending upon how it's couched, then the employer may not be liable. Now, what in the world is a frolic or detour? Well, let me give an example. Let's assume that an employee is charged with the duty of delivering an engine from their place of business at a machine shop to a customer's store. And while they are delivering the engine to the customer's store, they decide they are going to drive to their house and go meet their girlfriend or boyfriend. And while they are driving to their house 10 miles out of the way to meet their boyfriend or girlfriend, they negligently operate the vehicle such that it strikes another vehicle, causing property damage and bodily injury to the driver of the other vehicle. Would the employer be liable in that case? Well, let's take away the driving to the boyfriend or girlfriend and assume that instead the employee is driving straight from the machine shop to their customer store. If they operate their car negligently while driving it from their machine shop to the customer store, then yes, the employer is liable. That's the whole chapter we're discussing, the whole concept of respondeat superior. So the only difference here is that we have now embarked upon a separate venture, one not done for the benefit of the employer, one not authorized or approved by the employer, and one that's done strictly for the benefit of the employee. That is the very definition of a frolic and detour, and the law says that if the employee is negligent during the scope of that frolic or detour, then the employer will not be liable. Moving on to the next slide. The principal is liable for the intentional torts committed within the scope of employment. It doesn't matter if it's intentional or unintentional, if it's within the scope of employment. That is a very big key. The second bullet point is one that I tried to emphasize a couple of slides ago. The employee is also liable. The employee is a tortfeasor as well. In fact, if the employee is not liable for their own actions, then the principal or the employer is not liable either. They're only vicariously liable, which means that they're only liable if the employee is liable in the first place. And the final bullet point is the one that I was discussing in relation to a possible serious crime or other act. It doesn't have to be just a serious crime or other act, but the employer is liable if the employer knew or should have known the employee had a propensity to commit the type of act that they committed. We discussed early in the chapter the difference between an employee and an independent contractor. We discussed the distinction of the different type of factors in determining whether someone is an employee or an independent contractor. We also discussed how tax liability can be vastly different for a company if a worker is an independent contractor instead of being an employee. Well, in addition, a huge distinction exists as far as liability is concerned. The general rule is that a company is not liable for the actions of independent contractors. Why? Because the company has no right to control the actions of the independent contractor. You recall, I know, that the primary number one factor in determining whether someone is an employee or an independent contractor was this element of control. Did the company have the right to control them, whether or not they did? And it makes sense. If they can control them, they should control them. If they should control them, they should control them to the point where they do not commit tortious acts. If an independent contractor commits a tortious act, well, that's their own deal, because the employer does not have the right to control them in any fashion. Years ago, and I don't know if it still exists or not, but years ago, I used to use a delivery service to deliver packages and hand deliveries in the city. I think the name of the company was called Rabbit's Express. Well, I also had a secretary and a law clerk at the time, and occasionally the secretary or law clerk would also deliver packages or hand deliveries in town. If my secretary or law clerk made a delivery for me as an employee under the employer-employee relationship, they were covered by vicarious liability and the respondeat superior, and I was liable for their negligent or tortious conduct. On the other hand, Rabbit's Express, as an independent courier delivery service, was an independent contractor. If they ran over somebody en route to deliver my package, then that was their liability and not my own, because I had no right to control them as an independent contractor. It's very, very important to determine the difference and distinctions on whether a worker is an employee or independent contractor, because that is the key to so many other things related to liability or tax concerns. Exception to the general rule. If the company hires an independent contractor in the commission of hazardous or ultra-hazardous activities, in that case, the company is not liable, they are not able to escape liability. They are also liable for that independent contractor's tortious activities. And the law basically looks at this differently and says, this is such a hazardous activity. We want to make as sure as we can possibly make the safety of the public. And toward that end, what we're going to do is hold not only that the independent contractor will be liable, but also the company that hired them. They better be sure they're hiring someone that acts in a safe manner. Of course, the independent contractor in all of these circumstances are liable for their own torts. Slide 33 gives you a nice flow chart. You first determine what the worker's classification is, and then you determine whether or not it's outside the course and scope of employment or within the course and scope of employment to determine whether or not the principal is liable. Criminal acts are always very touchy, and in a large degree they vary from jurisdiction to jurisdiction. The general rule is always that the agent is liable. After that, perhaps the principal is not liable unless they authorized, knew, or participated in the crime. If that's the case, then the principal is always going to be liable. There is some gray area in between those two extremes, but for now, just be aware of those two extremes. How is an agency relationship terminated? First, the easy one, an act of the parties. They each agree, or one of them agrees to terminate the relationship. Second, by operation of law. Either one of them dies, for example. That will terminate the relationship. When the agency is terminated, the agent no longer has actual authority to bind the principal. However, principal's not off the hook necessarily. There still may be apparent authority, and apparent authority is enough to bind the principal. Do not get confused on an exam. I may very well ask questions related to whether or not an agent who lacks actual authority to bind the principal can nevertheless still bind the principal. And the answer there is yes, they can. Great true false type questions. True or false? An agent without actual authority to bind the principal can still bind the principal. Answer, true. As long as there's apparent authority, they can do so. Certain other acts will terminate the principal agency relationship if it's for a certain period of time or for a certain event, and that event has occurred or that time has elapsed. Some specific event, you're waiting for it to occur, or mutual agreement, or either party terminated. Death or insanity, impossibility, and change of circumstances also can change the nature of the principal agency relationship up to and including the point of terminating the principal agency relationship. The major thing that I want you to know from this chapter is for certain generally how to identify the difference between between an employee and an independent contractor, what the various differences are between an employee and an independent contractor as it relates to liability, including tax liability, tort liability, and contract liability. Some of the ways that an agency relationship can be formed, and the like. And that's all that I have for the agency chapter. Next chapter will be the formation of contracts. Thank you.